Thank you, Judge. All right, Ms. Whittaker, we'll get into the finances in just a second, but I want to talk a little bit about some of the text message communications between you and Mr. Whittaker. You've heard complaints in this case so far about some of your spending. Do you recall that?
Yes.
All right. And I'm going to show you what's been marked as P43. Do you recall this text message between you and Mr. Whittaker?
Yes.
And do you recall the date of this message?
That was, I believe, December 27th.
Was that one this, or if you look at the top, do you recall that?
I'm sorry. Yeah, that was November 29th, 2023.
Okay. And where was he located at this time on November 29th, 2023?
He was in Charlotte, Mecklenburg County Jail.
Okay. And you've not changed or modified this message in any way, is that right?
Right.
All right. Yeah, Judge, I move to introduce P43.
No objection.
43 is admitted.
Thank you. And in here, does he make any complaints about your spending of money in the year?
No, he says the opposite, in fact.
Okay. And what was your understanding in November of 2023 and December of 2023 of how you and Mr. Whittaker were going to resolve your case, your divorce?
At this point, we were in final settlement negotiations. I was spending a lot of time with my formal counsel, Keith Maples, to put together a final offer, which I believe at this point, it was around the end of November, early December, we did send a final and signed offer. We had, fine-tuned a lot of specific details, a lot of the what ifs, pending his criminal case. And I felt we were very close to finalizing the divorce, which we had agreed was in the best interest of the
Your Honor, I'm
children.
going to object to the testimony about close or not close under settlement discussions. If we want to waive the settlement discussions confidentiality, that's one thing. But if we're going to just comment around the edges, I don't think that's appropriate. So my objection is these are settlement discussions.
So I'm going to disagree. Their settlement negotiations. She's just telling what she thought where they were at, because that goes to the motivation and why we're still in this litigation, and $400,000 have been spent total in attorney's fees on a family law case.
So are we, because that's always the case in every family court case, where there is a time where you don't reach a settlement and you go to trial. So generally we keep out settlement negotiations and communications.
Right.
But if both sides want to wait, I heard Mr. Kazin say he's okay not keeping that out. And so if we want to allow the parties to talk about it, that's okay with me. And then the other part of that is it can also come in for other reasons, but it can't be hit and miss. Right now, Ms. Locke, I think your problem is you want to put it in for your purposes, but not let him put it in for his purposes. So you got to choose a side.
Well, but Judge, I wasn't going to put in the actual settlement.
But you were, though. You were putting in you were close, all those different things. Like that's actually the sort of thing that we generally don't allow unless there's a reason for it. But if you're going to bring it in about motive, then he's going to get to bring in it about motive too. I just want you to be careful. And I don't have a rooting interest here. I always want to know what happened in mediation. Always. And so it's the parties who generally don't want me to know, but I'm always good with it. So if you both want to waive and tell me why we're here, I'd be great. But I don't know that you both do. And I worry that if you ask her more questions down the path of mediation, then it's just going to allow the whole door to be wide open, Ms. Locke.
I'll ask my next question, Judge.
Okay.
We previously talked about the power of attorney, and at some point of it, they had sent correspondence regarding their intent to revoke the power of attorney, right?
Yes.
All right. And when you had access to the power of attorney, did you have access to all of Mr. Whittaker's email accounts and online accounts?
Yes.
Okay. Did he have a Discord account?
Yes.
Out of curiosity, were you aware of whether he had a Snapchat account?
I didn't ever access a Snapchat account, I don't believe. But yes, I believe that he had one because he asked, or I know that he had one because he asked me to send him Snapchats prior to the separation.
Okay. And you were able, during the time that you had the power of attorney, to access his search history, is that right?
Yes.
Okay. And did you access a search history at any other time other than when you had the power of attorney?
I can't recall.
Okay. Do you recall the search histories that you saw that he was looking up in around November of 2023?
Yes.
Okay.
2022.
I'm sorry, 2022. And what were the search histories in November of 2022?
In summary, how to hack a home Wi-Fi, how to stalk my wife, why do I have a need to spy on my wife? I never was a stalker, but now I am. Impatient, sex addiction, rehab, things of that nature, how to keep my wife from getting half my business. Those were the gist of the searches.
And in December of 2022, did he have additional searches?
That I believe was the time frame around where most of the stalking and hacking a home Wi-Fi was occurring.
And at the same time that he was searching these items in December of 2022, what was he telling you at the same time?
The same date that the searches occurred was the date that he told me he asked Jesus into his heart to come be his Lord and Savior.
Okay. And let's move forward to December of 2023. I'm going to share what's been marked as Petitioner's Exhibit 44. And these are correspondences between you, or from Mr. Whittaker, not between you, it's just from him in December of 2023. Is that right?
Correct.
And this is a copy of the correspondence and you've not changed it, right?
Correct.
All right. I move to introduce P44.
No objection, Judge.
What did
It's
Mr.
admitted.
Whittaker? Oh, I'm
Sorry,
sorry.
44 is admitted.
I'm so sorry, Judge. What did Mr. Whittaker tell you about passwords and accessing accounts, etc.?
There had been some phone discussions at the time that he revoked my power of attorney, that given the workload that was on my plate at that point, with this being a really important Christmas for the kids, we were in the middle of selling our home. We were in the middle of selling the business. It was the end of the year for my job, which is always the most demanding time. So I had changed a lot. I was managing everything. I had 3 phones, 2 mortgages. So I had, for a lot of Rusty's accounts, I had just put the passwords as my passwords.
Okay, and so, well, hang on. And so I'm asking you, what did Mr. Whittaker say to you on December 29th, 2023? Can you read what he sent?
It would be helpful if you give Dusty my password list as well. He will not access any funds in our joint accounts. You can even move the funds to your individual accounts if you would prefer. I just need that list so we can get to work on a few things, insurance, tax, and credit related. He also needs my phone. He was trying to freeze my credit, but couldn't do it without my phone. Please let me know
Sorry, go ahead.
Please let me know if you have any other concerns that would prevent you from giving him the rest of my personal effects.
Okay. And so this was after, when was this message in relationship to the letter that said they intend to revoke the power of attorney?
The revocation letter came on December 12th, and this text was December 29th.
And so were you still coordinating with Mr. Whittaker and his brother with regards to getting all the accounts transferred back so that Mr. Whittaker could access them?
Yes.
Okay. And you understand now they're complaining about that. You recall that?
Yes.
Okay. Let's go to the next text message. Has Mr. Whittaker thanked you for all the work you've done?
Not, he early on, while I was doing all of the work, told me thank you, but since has changed his direction on how he feels about everything that I did.
Let's show you what's been marked as well, let me back up. When did he become super religious?
It was after, I would say that he really jumped head first after I kicked him out of the house for finding the camera. And it was a fast and furious process to asking Jesus into his heart, and then a month later getting baptized at the church.
Okay, and let's show the court. I'm gonna show you what's been marked as P68. So this is another text message on from what date with Mr. Whittaker?
This looks to be June 26th of 2023.
All right, and you've not changed or modified this in any way, is that correct?
Correct.
All right, Judge, I move to introduce P68.
No objection.
P68 is admitted.
All right, can you read what he says, starting with, "I am so grateful"?
I am so grateful for the army of people you are leading to guide you and the kids and my clients through this tough time. I'm grateful for your parents, Lance, Ryan, Mark, Yuri, Deanne, Bill, Rick, Carson, Vanya, Dusty, and the list goes on. I am confident this is all part of God's plan. No matter how painful and challenging it feels, He will carry us through it. This is not how many of us would have scripted things, but He doesn't do things the way we want. If we stay truly connected to Jesus and share our hearts, our fears, anxiety, doubts, and our wants, those are the moments that God shows up and does amazing things.
Can I interrupt for a second? There's
Yes,
a
Your Honor.
There's a Sarah Sosa in the waiting room. Is that somebody I am supposed to allow in?
It's my
Or not.
legal assistant. I'm not sure. I did not know she was going to log in, but she is my legal assistant, Your Honor.
Okay, I'm fine to allow her in. I just wanted to make sure before I did so that everyone knew what was going on. Okay,
Sure.
I will allow her in. And then you can continue forward, Ms. Luck. Sorry to interrupt.
No, totally fine, Judge. I'm going to share what's been marked as P62. All right, and this is another message between you and Mr. Whittaker on what date, Ms. Whittaker?
This was August 17th of 2023.
Okay. And you've not changed, modified this in any way, is that correct?
That's correct.
All right. Judge, I move to introduce P62.
No objection.
62 is admitted.
All right. And I want you to read the last part of the message. Well, it looks like we're missing part of it, but this part of the message that he sent to you, Mr. Whittaker.
Lacey, I'm not judging or criticizing anything. You've got a lot on your plate, and I know you're doing your best. I tell you, I'm proud of you, but the word isn't big enough.
And I think it's for what you have
Right.
done, but it's cut off. So when did this shift change from him being grateful and appreciative to revoking your power of attorney and this turning into what it is now?
Once we had a contract on the house, we had a lot of unknowns financially because the business was in the look-back period. We didn't know what the ultimate valuation was going to be. Our house is a big financial burden every month, and we hadn't had a contract on it, so we didn't know what the final numbers were going to look like. Once we had those final numbers, we had a contract on the house, we had a pretty solid understanding of what the business valuation was going to look like. That was when everything changed, in my opinion.
Did he need you anymore after that point?
Exactly. No, he didn't need me because I had done all the heavy lifting.
Let's go. When you married Mr. Whittaker, did you figure this was going to be the plan for your life?
Absolutely not.
Okay. How has this affected you personally?
I have experienced some of the biggest traumatizing events that happen in a person's lifetime, all in the span of a 2-year period. I have I'm I had 10 years of tenure at a company in a job I was performing well at. I have 3 beautiful children. We were, on track to achieve our goals in life. And overnight, my world has been turned upside down. And I am now a full-time single mother of 3 very young children who need me, who are also experiencing trauma that I have to be strong for. My career is in jeopardy. My future is completely different because of what Mr. Whittaker has done and the situation that he's put us in. I have been taken advantage of in so many ways.
By
And
who?
by Mr. Whittaker and many of the vultures that have come afterwards and sensing vulnerability. For example, the landlord, Frank, the landlord of Rusty's residence, which I had to manage. He had just signed a lease on a townhome 15 days, I think, prior to his arrest. The landlord was not happy about the FBI raiding his home, his brand new home.
Well, okay, but you had to manage the landlord and.
Yes.
But what else has this done to you personally?
And
Well, let me rephrase. How are you holding it together?
I am hanging on. I mean, I feel that I'm really proud of myself for all that I've been able to do. I mean, I've become essentially a widow overnight and maintained my job. I've moved, I've sold a business, I've sold a house. I've done a lot, but it has been so incredibly overwhelming and stressful. And I don't know sometimes how I'm going to get through the next day. I don't know not only how I'm going to get through the next day, but how am I going to help 3 young children get through it the next day who are also experiencing the sudden loss of, sudden change, moving, all the same traumas that that affect people in, physical and mental senses. My focus, my health is suffering. I have trouble sleeping. I'm anxious. I'm tired. I have brain fog. I feel you can see I'm nervous. My words don't come out as smoothly as they used to. And I have been on unstable ground for so long since this has happened. There's no reason we should still be sitting here at this moment. This should have been resolved over a year ago.
Okay, but hang
and-
on. So you're asking for a big disproportionate division. What are some of the things that you've taken into consideration as to why you're asking for that big disproportionate division, especially as it relates to the children?
Because I'm now parent number 1 and parent number 2, and I'm gonna need a lot of help to fill the gap that's there as a result of Mr. Whittaker's choices and actions and absence moving forward, very likely for their entire childhood. I'm gonna need a lot of help and a lot of arms to wrap around my children, because even on my very best day and on my kids' very best day, I am not enough for 3 kids. I'm just not enough. They all need love and attention. I have to be there now because I'm parent 1 and 2 for all the school events, for all the games. I have to physically be present, and that requires, a sacrifice somewhere else. That means that I'm not going to be able to work as hard as I've traditionally worked. I'm not going to have the earning potential to be able to cover even basic expenses and daycare for my kids if I don't have help.
Yeah, let's talk, hang on, let's talk about the expenses a little bit. Julie's still in daycare.
Yes.
Okay, and what does the daycare run you a month?
It's $400 per week just for tuition.
Okay. What other expenses does she have related to the daycare other than the tuition per week?
There are administrative fees. There are, teacher appreciation gifts. Next year, I believe she'll be in uniforms, so I'll have to purchase uniforms.
Is it
There's-
Primrose? Is she a Primrose still?
Yes.
And so you've had to hire a nanny, is that right?
I have hired, and actually I did a lot of research on the most cost-effective and beneficial type of help that I could get, and I settled on an au pair who actually lives in the house with us, who can help me in the hours that are really difficult to get covered, like early in the mornings when I have to be in the OR and daycare's not open till 7:30, or later in the evenings on,
Oh,
you know.
okay, hang on. And so let's talk about how much the au pair has cost you thus far, okay? What was the cost for the au pair? If you can recall, and if you need to refresh your recollection, I've got an email for you.
Yeah, a refresher would be nice so I can be exact.
Sure. I'm going to show you what's been marked as P45. And so I just want you to review it real fast to refresh your recollection. And sorry, Judge, I don't know how else to refresh recollection on Zoom.
Yeah, this is, so there's the
Well,
agency fee.
Ms. Whittaker, wait just a second. I just need you to finish reviewing it first. I need the judge's input if this is okay, because that's my concern.
Well, it's okay with me. I think it's more of a question for Mr. Kazin. And if perhaps you need to send him this, you're not admitting this, I guess. This is notes.
No, this is an email correspondence between my client and the agency. So
Right, but
technically,
I'm saying it's technically going to be notes, because that
Correct.
Mr. Kazin, as long as he's seen them,
oh, he's seen this.
okay, then I don't have a problem with her looking at it. But that's a question for Mr. Kazin.
I don't have a problem with her looking at it, Your Honor.
All right, so thank you, Mr. Kazin. So Ms. Whittaker, I need you to look at all of it and then tell me when you're done and if your recollection has been refreshed.
Yes, I'm refreshed.
Okay. All right, so what were your initial expenses with the au pair?
I paid an annual agency fee to Cultural Care Au Pair for $10,595.
Okay,
And then there's a weekly stipend paid directly to the au pair. I pay her $200 a week. I'm also required to for room and board. So, I had to rent a home big enough to have an extra bedroom for an au pair. I pay for, additional costs and groceries to feed the au pair. I had to buy a vehicle for her because I need help with the transportation of the children, and my vehicle is a company vehicle that she's not allowed to drive.
did you
So
buy a vehicle for her?
I did, yes.
How much did you spend on that vehicle?
Approximately $17,000.
Okay. All right, what other expenses do you have with regards to the au pair?
There's a tuition. They're required to take a course through their stay, and I have to pay $500 towards that course. And then I pay insurance on the vehicle for her and the home.
And the tuition is 500?
Yes.
Okay. And is there any other costs?
Just other than, having another person in the home to celebrate on birthdays and whatever.
All right, so you've paid the agency fee to date, that 10,000, a little over 500, 10,500, right?
Yeah.
Okay.
Yes,
And at any point, and you're paying her 200 a week, is that right?
correct.
And how long has she been with you?
Since September.
Of what?
September 1st.
Of what year?
2024.
Okay, thank you. And has Mr. Whittaker in any way helped provide support for this au pair?
No,
Have you been provided any reimbursement from any of the trust accounts that relates to this au pair?
no.
Okay. What reimbursements, to the best of your knowledge, has Mr. Whittaker gotten under the, let me rephrase that. What reimbursements has Mr. Whittaker received as it relates to his expenses related to the children while this case has been pending?
0.
Okay. Has he traveled here?
Yes.
Okay. Do you
Oh.
know if, sorry, do you know if he got reimbursed for any of the expenses relating to him coming to do visits here?
I believe he did. Yes.
Okay. And do you recall what that included, all those reimbursements?
I know for sure that he was reimbursed for the supervised visitation fees to the agency that supervised the visits.
Okay. And do you know if he's reimbursed for flights?
I don't know. I don't recall.
Okay. Do you think that you should have been reimbursed for the cost relating to the au pair?
Yes,
Okay. Are you asking the court to make an order of reimbursement to you for the costs you've paid to the au pair to date?
yes.
All right, 1 second. Let me pull up I'm going to show you now what's been marked as P77. We're going to talk about finances for a second. All right. And this, Ms. Whittaker, is your proposed property division with the relatively updated, updated from our perspective numbers, but we're still missing numbers related to Mr. Whittaker. Is that correct?
I believe so, yes.
Okay. And this is how you're asking the court to divide the marital estate as it sits here today, correct? I can scroll down. Whoops, sorry.
Yeah, I know there's been a lot of revisions to this document, so I'm,
But no, please look at it.
yeah.
Is that correct, Ms. Whittaker?
Um,
And you see it's the split down here.
I didn't see, the request for lump sum child support, and I also don't see attorney fees to date.
The attorney's fees for protective order here, the other attorney's fees to date aren't on this spreadsheet. They're just marked as X's for both sides, but we still have the waste claims on here. Give me 1 second. Let me stop the share so everyone stops seeing it on the internet.
I don't know if it'll help the court or not, but I don't see P77 in box.
It's in box. I know it's in box. Maybe click refresh, Mr. Kazin, because I know it's there.
Okay.
Let me know if you have it, Mr. Kazin. If not, I can have Mr.
No,
Diaz.
I did have to refresh, but I see it.
Okay, and Ms. Whittaker, let me show you where the I just had them up, the waste claims are, and now I can't find it. I'm sorry, Judge, spreadsheets are not ever my friend. Here we go. It's page 2 of 4. Ms. Whittaker, here you go. You see these lines, starting under 94?
Oh, yes.
Right, and we address the child support separately, but this is the spreadsheet of the property that it relates to the marital estate and what the court has to divide sitting here today, right?
Yes,
And this is the division that you are asking the court to do. Is that correct?
yes.
All right, I move to introduce P77.
Your Honor, I don't have any objection to it being admitted as an exhibit and as a summary of her request, but as being accepted as her pretrial, I think you've got to do them by the response date and or file a motion for leave to amend. This is the first time seeing it, so as an exhibit, I don't have a problem with it, but as
Okay, I hear what you're saying. Let's go ahead and admit 77, but I recognize this is the first time you're seeing this and that it may be that you need a chance to look at it. You don't want to try anything by consent. I'm not really for sure either, but I'm going to go ahead and admit it just so we can all know what we're looking at and the record can be preserved. But I recognize it's not evidence for the truth of the matter asserted. It's more of a position paper for Ms. Locke.
Correct. And we're gonna go over the values in just a second, Judge, but I can tell you when Mr. Kazin, there are some number of differences, but Mr. Kazin's, I don't think is gonna have any disagreement with the numbers on here, other than, I think some of the waste claims, of course, he disputes, but I don't think there's any dispute over the actual numbers. But I'm gonna go over them with my client. So Ms. Whittaker, on your USAA account ending in 4818, when was the last time you checked that balance?
Today,
And what is that balance sitting here today?
775 and 5 cents.
All right. And the joint Goldman Sachs account ending in 6394, when was the last time you looked at that account?
Today,
Okay, and what is the balance of that account as of today?
$803.
Okay, and you looked at your particular Goldman Sachs savings account, right?
Yes,
And when did you look at that last?
today.
And what was the value of that?
120, I actually think it was 121,000. I think we got a few $100 interest payment.
Okay. But the last time you had looked at the balance, it was the 120,000 as reflected on the spreadsheet.
Yes,
Okay. The Wells Fargo checking ending in 6893, when was the last time you looked at that balance?
today,
And what was the balance as of today?
14,758.
Okay. And then your Wells Fargo savings ending in 7022. When was the last time you looked at that account balance?
Today,
And what was that account balance?
3,110.
Okay. And have we had issues with getting access to the values of accounts of Mr. Whittaker?
Yes,
Do you recall me asking last week for screenshots of recent balances for his accounts?
yes,
And to your knowledge, have you seen any of those screenshots?
no,
And his brother has a power of attorney, is that your understanding?
yes,
And his brother, can he access all of the accounts that Mr. Whittaker has?
yes.
Okay. And did they provide the documents in discovery, or did we have to issue subpoenas to get the documents for bank accounts?
We had to issue subpoenas.
Your Honor, uh,
Judge, I don't know what the legal objection is.
yeah, I'm trying to figure out my legal objection, but that's there was an order that was negotiated and is in the court record about this. That was all done by consent. So the characterization, I'll object to the ambiguity and the mischaracterization.
I'm not really, y'all are probably more up to date on that issue than I am. So as to now, I'm going to have to overrule that objection. I'm just gonna have to leave it for you to be a matter you take up on cross, Mr. Kazin. We'll just have to stick a pin in that, and we'll have to come back to it.
Yes, ma'am. Thank you.
Ms. Whittaker, just real briefly, how many times did Mr. Kazin bring us back to court on motions to compel for supplemental documents?
I lost count.
Okay. Was it more than 3?
I believe so, yes.
Okay. Let's see. And so the numbers on here with regards to Mr. Whittaker's accounts, we haven't updated simply because why?
We have not gotten any updates.
Okay. So let's talk about your Family First bank account. When was the last time you looked at that account balance?
A long time, I don't even recall. It was sometime around 2020, I think, when I closed the account or liquidated the account.
And does it still have a balance that's reflected on the spreadsheet?
I think there was a small balance still in the account. Last time I called,
And what was that balance?
like $6 and something.
Okay.
Can't.
Let's talk about, sorry, your GE Healthcare Retirement Savings Plan. The current value of that is what?
I haven't looked at this one as recently, but as of what 10/20, it was 717,291.
Okay. And there's a separate property claim in that one, is that right?
Yes,
Okay, and that is reflected in the expert report by Ms. Desai. But by the way, are you aware of Mr. Whittaker hiring a tracing expert in his case?
yes,
And was it a Mr. Metz?
yes, Robert Metz.
Okay, and to this date, sitting here, have we received any reports from Mr. Metz?
I have not seen any reports from Mr. Metz.
Okay, you heard that about them talking about the goodwill portion of the claim. Have you seen any expert reports relating to the goodwill for that business?
No,
Okay. Have you seen any expert reports regarding tracing of separate property claims?
no,
Okay. You also have a Victory Funds IRA, and that one is, you believe, a separate property. Is that right?
yes.
Can you tell the court why that one is your separate property?
That was an IRA from a company that I worked for prior to marriage, and I haven't touched it since uh,
And
prior to the
so,
marriage.
sorry, I didn't mean to interrupt. Have you made any additions or contributions to that IRA during the marriage?
No,
Okay. Has it been a self-contained account the entirety of the marriage?
yes,
Is there any doubt in your mind that it's separate property?
no.
What about the Waste Management Long Share Savings Plan? What is that?
That was a employee stock purchase program that I had when I worked for Waste Management from, I believe, 2010 to 2012.
Okay. And there was a portion of that was, so it was created prior to marriage?
Yes,
Do you remember the date it was created?
it would have been in August of 2010, I believe. Possibly, I was an intern for the company over the summer in June of 2010, and then I was officially hired as a full-time employee in August of 2010. So it would have been somewhere in that time frame.
Okay. And we have a report from Ms. Desai that has traced some of that as separate property versus some community property portion. Is that right?
Yes.
And what was your recollection as to why there was some community property portion in that waste management savings plan?
I believe it was just dividend reinvestment.
Okay. And let's go down to the Charles Schwab brokerage accounts. These are the accounts that are with the UT account, the Uniform Transfer of Minor Acts, the UTM accounts, right?
No,
Okay,
I
then
don't
what?
believe so.
Okay, and then what are those then?
I believe, so we had 3 accounts for each child. We had a UTMA, an NY Saves, and a brokerage account. So I believe these ones represented in this portion of the spreadsheet are the brokerage accounts. So they're
Okay.
basically investment accounts.
All right. Um, and you looked at these values as of what date?
I don't recall. I think maybe it was Rusty that would have updated those numbers in mediation perhaps, because I don't have visibility to them anymore.
Okay. But do you have any reason to believe these numbers are incorrect?
No,
Sitting here today, do you have access to those accounts?
no.
When was the last time you had access to those accounts?
Um, uh, probably early this year. I don't recall.
Okay. The life insurance policies, do they have any cash surrender value?
Not that I'm aware of.
And you're asking that each party take their own life insurance policies, is that right?
Yes.
Okay. And what are you asking with regards to one of the policies for Mr. Whittaker and how he maintains beneficiary status on it?
That I remain the beneficiary as long as the children are in my care.
Okay. There's been some, you've seen on Mr. Whittaker's spreadsheet that he's put the Spanish Oaks membership at a value of like $75,000. You recall that?
Yes.
Can you explain to the court what is going on with the Spanish Oaks membership?
So it has been frozen for, as far as monthly dues go, it's been frozen since June of 2023. So we haven't had to pay any monthly dues on that membership. When we joined, there was an initiation fee of $100,000, which 75,000 of that was an equity portion. So when you sell the membership, you get your equity back. However, I've been informed that the time frame to receive your equity back from selling a membership is north of 10 years as of today, with the wait list of people selling their memberships and the new price of memberships today. So my understanding is that $75,000, we won't see it for at least 10 years.
Okay. Is there a possibility, to the best of your knowledge, that it could be longer than 10 years?
Yes.
Okay. Do you think that it's well, scratch that. Is it something you could market and sell today?
No.
Is there any guarantee as to the marketability or saleability of it down the road?
I am completely at the mercy of the club to sell the membership. I have no control over that.
Okay. And this is where we were talking about how we distribute the funds that are held, the trust funds that remain to be held by the attorneys. And you were asking that out of Mr. Whittaker being awarded $100,000 from the trust account at my account, you're asking that what happened with that $100,000?
That I would like to be prepaid as child support.
Okay. And are you asking the court to order Colwell Bowes to issue a check to the OAG to cover the child support?
Yes.
All right, let's look at. Has he told you what's happened with the Cadillac Escalade?
No.
Is there any cash value in the Blue Jack National membership?
No.
Is that a monthly expense?
Annual.
Okay. And let's go to the expenses that he's accumulated while the payments to the criminal attorneys. You were directly involved with the hiring of that criminal defense attorney, is that right?
I did, yes. I called and interviewed multiple attorneys to try and set up consultations for Mr. Whittaker.
And how much was paid to the criminal attorney that he retained?
I believe that we transferred out of the trust account after the sale of the home $150,000, but I do believe there's been there's a retainer. I don't have documentation, but my understanding is there's also an additional retainer that needed to be paid for expert consultation as far as the criminal attorney goes.
Okay. And what about how much was his criminal bond payment when he bonded out in February of 24?
The bond was set at 25,000, but I believe there was even more, like there was a $1,000 like bond fee, a non-refundable fee on top of that.
And what are you asking the court to do with regards to the $175,000 related to his alleged bad acts?
I would like for that to come out of Rusty's side of the spreadsheet. I don't want to have anything to do with the criminal component financially or otherwise.
Tell me this, are you worried about if he receives a substantial portion of the estate, what happens if there's civil liability related to his charges?
Yes.
And what are those concerns?
I have a couple of concerns. I'm concerned that he could use that money to pay off the family, to pay off, someone in the process, to get off free of his charges. I'm concerned that he might use that money to cause harm to me or to my family. I am concerned that he'll continue to use that money to force me to go to court in a situation that I am not able to afford to keep on going to court because I've spent all my money on attorney fees and I'm barely able to keep my head above water to pay for the kids. I am concerned that there's corruption and manipulation in this process, and I don't feel that anything good will happen if he has access to a large amount of cash, given the bleak future that he's facing.
Let's talk about the Pokemon cards for a second. These are pictures of the Pokemon cards. This is P36 that you took in this case. Is that correct?
Yes,
You've not changed or modified these pictures in any way. Is that right?
correct.
Okay. And this is an accurate picture of, is it all the Pokemon cards? What is it exactly?
These were, I mean, there's Pokemon cards in my couch cushions. I can't guarantee this is all the Pokemon cards, but these were all the Pokemon cards that were, I've had to move a couple times now too. So these were in the boxes that I had. These were definitely all the cards of value, that were in cases or, books contained, and all the unopened packs of Pokemon cards and the Japanese cards as well.
Okay. And there's 186 pictures of Pokemon cards. Is that right?
Is that right? That's a lot of pictures.
Well, we're going through them real briefly, but these are the ones you took because you had to inventory them, right?
Yes,
All right. Judge, I'd move to introduce P36.
No objection to P36, Judge.
36 is admitted.
Okay. You came up with a number that related to Pokemon card purchases. Where did that number come from, Miss Whittaker?
those were the totals on his credit card statement for all the purchases that he made between the months of, I think, September and November of 2022, when he was in the other bedroom after the Kalahari incident.
Okay, so from September to November of 2022, he made $12,000 in purchases of Pokemon cards.
Almost $13,000, yes.
Had Pokemon cards ever been a thing for him before?
There was mild interest in Pokemon with Weston, but no, to this caliber, absolutely not.
How did this come up that all of a sudden the interest in Pokemon cards, if you know?
I know when we were still in the same bed, I know that Rusty was in Discord chat rooms playing Pokemon games till all hours of the night. Getting these boxes that are guaranteed to have certain value cards in them. And you pay a certain amount for the box, and then we were getting Pokemon card deliveries to our doorstep multiple times a day after that.
Were they for your son?
That was what he said.
Okay. Did you find that to be an accurate statement?
I don't think, I think this far exceeds any reasonable purchase for our son for Pokemon cards.
Okay. Are you asking the court to reconstitute the marital estate based on these wasted funds on Pokemon cards?
Yes, and because of what I feel they represent.
Okay. And you actually looked through the statements and came up with how much he spent on travel to North Carolina on that May 20th date. Is that right?
Yes,
And how did you come up with that number of $1,051.50?
it's totaling the airfare, the Ubers, or the Lyft, transportation, the churro, and the hotels.
Okay. And do you think the marital estate should be reconstituted for that activity?
Yes,
And the supervision fees, where did you get that number from?
that was from the document provided from the trust account at Mr. Kazen's office.
Okay. You have, tell me about the $816.68 for the mobile phone that you had to pay. What happened with that? That was Mr. Whittaker's mobile phone. What happened with it?
The FBI seized it.
Okay. And what was left on it?
I think there was $816.68 left to pay off the phone itself.
Okay. Are you asking the court to reconstitute the estate based on you having to pay off the seized phone?
Yes,
You're asking the court that you keep your own debt in your name, correct?
yes.
Tax liabilities, we've already addressed that. Let's talk about the funds that are still owed from the business. And there it is. So this is actually a number that is the same on Mr. Kazan's spreadsheet. Is that right? The 909,000?
I believe so, yes.
Okay.
Your
And
Honor, I don't know if you'll permit me to clarify this. I think it'll be an aid. I'm not trying to disrupt council's flow, but I think I've got some information that could just be useful here.
it's fine with me, Judge.
We received a payment overnight, maybe the night, it was either last night or the night before last. Mr. McBride, who is the payor on the business, makes business payments, $25,000 a month, first of the month. That was received in our trust account. I have reduced the amount outstanding on our spreadsheet, and I have increased the amount in my trust account, although there was a $3,000 payment that was already court ordered for Mr. Whittaker for various expenses while he's incarcerated. And so the number on our spreadsheet we think is correct because it reflects $22,000 more in the trust money that is in my account versus what Ms. Locke currently has reflected on her spreadsheet. So I just thought I want to just provide the court that information.
And I have no problem updating the spreadsheet. I would just like the documentation on that because it's the first I've heard. So, all right, as long as I get the documentation, I have no problem updating the numbers.
Sure, that sounds good to me. It sounds like y'all are working on something together. You got tonight too, so we can also do
Right.
that. And y'all
Your
can
Honor, I would
collaborate.
just tell counsel if she would look at R 129. It's a late addition to our exhibits, but it should be in box. R 129 is the screenshot I made of the receipt of the additional payment from Mr. McBride.
Thank you,
All right.
Thank you, Mr. Kazan. All right, now that we've covered the spreadsheet, Ms. Whittaker, this is how you're asking the court to divide the marital estate. Is that right?
I believe so, yes.
And do you believe that what you've requested today is a just and right division, given the circumstances of this case?
I believe it's more than just and right.
Okay. I pass the witness. Oh, I'll stop my share, sorry.
I think this is a good time. Let's go ahead and take a break. We'll take a 10-minute break, Mr. Kazan, and you can figure out where you want to start and we'll come back after that. Thank you.
Could I, before we go off,
Sure.
Ms. Locke, would you mind, I've sent you a link to every one of our exhibits. Would you mind at least sending me the spreadsheet that we just went through, R70 or P77, so that I can use it without?
Sorry. Mr. Kazan, we'll send you a link to all of our exhibits. We always do that. I'm sorry if we did not. You will get that. That's not a problem.
Great, thank you very much.
Thank you.
All right, everyone, I'm back. And we have passed the witness and you're up, Mr. Kazan. Let's see. I don't know that I see Miss Whittaker. She's coming back on the video now. There she is.
So,
Mr. Kazan, you are muted.
Sorry.
That's all right.
Still learning, always. Are we about 3.5 hours in? Now you're muted, I believe, Your Honor.
Yes.
Okay.
I think
ma'am,
I think I have Miss Locke at about 2 hours and 50 minutes because you're taking breaks and so I think that's about where I am.
Thank you, Judge.
Ms. Whittaker, can you hear me?
yes.
Okay, sure. I've got some questions for you. I'm gonna start with some of the things that you initially talked about in your openings direct. All right. I'm showing you on the screen what's been marked as Respondents Exhibit 1. Do you remember this document?
Yes, I do.
And it's one that you produced. It's got your Bates number down here at the bottom, correct?
Yes.
Travis County Sheriff's Department report. Would you agree?
Yes.
Offer a Respondents Exhibit number 1.
I object as to hearsay.
Overruled. Respondents 1 is admitted.
Thank you.
So, ma'am, do you see the highlighted stuff on the screen, ma'am?
Yes,
Okay. It's true. This is about the 2019 incident that was in your protective order application. Is that right?
I believe so, yes.
All right. As a matter of fact, I'm gonna come back to that. It's already admitted, but I'll come back to it. I want to ask you about a couple of the other incidents. You started off going through two different items in your testimony about things that you thought were episodes where Mr. Whittaker was aggressive. Do you recall that before your marriage? Do you recall that, ma'am?
Yes,
And one was in Mexico and one was in your home, I believe. Is that right?
in Mr. Whitaker's home, yes.
Mr. Whittaker's home. The one in Mexico had an episode where you were in a fight and he ended up going to a wedding without you. That happened, didn't it?
Yes,
And you were intoxicated on that occasion, were you not?
we had been at the pool drinking. I would not say that I was intoxicated, but we had definitely had some drinks that day.
Okay, and you were arguing, and is that the event where he didn't like what you were wearing, or was the argument over something else?
No, I don't even recall what we were arguing about.
I see. And there were no authorities called, is that correct?
Correct,
There were no injuries for which somebody needed to go to the hospital, correct?
correct.
There was no complaint by the hotel, correct?
Not that I'm aware of.
Right. So, and the same on the other event where at Mr. Whittaker's residence, you say there was a disagreement. You wanted to feed him some cookie dough. He threw the cookies away. No cops were called. Agreed?
Correct,
No hospitalizations, correct?
correct,
No photos of any injuries, correct?
correct.
So, ma'am, you included these events in your affidavit supporting your request for protective order, did you not?
I did, yes.
Protective order, would you agree with me, is a fairly serious matter?
I would, yes.
And these two incidents we just first went through were before your marriage, right?
Correct.
And you went ahead and got married anyway, right?
I did.
So, ma'am, did you feel like you should just put all of your arguments with Mr. Whittaker in your affidavit supporting your request for protective order?
I took the guidance of my counsel in crafting the protective order.
Okay, but nothing violent happened on either of the first two incidents we just covered, right?
That's not correct.
Well, in one of them, you said he looked, it says in your affidavit for protective order, he looked at you in a way that looked like he wanted to kill you. Do you recall that?
I do.
He didn't say those words. You just gratuitously threw that into your application for protective order, requesting that the court do something about it, right?
That was one small part of a story, a sequence of events, yes.
Okay, so no violence, nobody called the cops, but because those were the facts, you felt like it was important for the court to know the way he looked at you made it feel like he wanted to kill you.
There was violence, not that particular part of the history was violent, I felt.
I'm asking about the look, because you specifically put in your declaration that he gave you a look that made you think he wanted to kill you. You did that, right? You put that in your declaration?
I did, yes.
You don't know what was going on through his mind, right? You can't read his mind.
I cannot.
He didn't say those words. You just felt like putting that in your declaration, right?
That was my experience, yes.
Okay, now I want to ask you about the 2019 incident, and I'll take you back to the exhibit we were about to look at. This is Respondent's Exhibit number 1. And you see the narrative of the sheriff here. Do you see that?
Judge, I'm
I
still
see
gonna
it.
object as that's hearsay.
I think the court's already addressed this, Your Honor.
That's my objection.
Overruled.
Thank you.
So can you follow? You've read this document before, have you not, Ms. Whittaker?
I have, yes.
And it reads to you like the first couple of paragraphs read as what you said to the officer at the 2019 incident. Would you agree?
Yes.
And you see this where I'm pointing with this big fat cursor that I've got this big, do you see the cursor, by the way?
I see it, yes.
Okay. And so it says Lacey stated Rusty was lying on a couch in a playroom when Rusty told her he was leaving. Did I read that correctly?
Yes.
And then it recites, Lacey stated she told him, meaning Rusty, he was not leaving as she needed help with the children. Did I read that
Yes.
correctly? And then it says Rusty grabbed his keys and she told him, I want to make sure I'm reading this correctly. She told him he's not leaving, quote, you'll have to run over me. Did I read that correctly?
You read that correctly.
Is that what you told the officer?
It is probably close to what I told the officer, yes.
Okay. And yet, when we go to your protective order affidavit, I'm sorry, Your Honor, I asked to have admitted number 2, which we just went through. This is number 1. Nonetheless, I'm going to ask for this to be admitted also. The protective order affidavit is 01, and the police report that we just came from is respondents 2. I'm offering 1 now with that verbal correction.
No objections.
So do you see this statement that you made, Ms. Whittaker, in?
I'm sorry, Judge, did you admit number 2? I didn't hear.
I didn't know that they offered 2. This was 1. They offered 1, and I said I admitted 1. Was 2 the police report? I don't think
Yes,
so.
I misstated it when I was showing the police report. I called it 1, but it was actually 2. That's the only
Okay.
problem.
So then 2 was admitted, but 2 is admitted.
Okay,
Yeah,
And it was,
I-
Ms. Locke had an objection. I overruled the objection. I don't want her to get prejudiced in some way. We'll just note that for the record.
Thank you,
Those
Judge.
were hearsay objections on 2 that I overruled.
Thank you.
And I also heard her say no objection when I offered 1.
She
Correct.
was fine with the actual 1. Yes.
Correct.
That's correct. Okay, so Ms. Whittaker, back to your affidavit. I'm showing you the affidavit, and here it says, he threatened through the door that he wouldn't hesitate to run me over if I opened it again. That's the opposite of what you said to the officer. Would you agree with me?
It is not the opposite. I think this is 2 pieces of the story and both are true.
Well, even if both might be true, one is actually opposite from the other, isn't it?
Well, no, because in this report, this was before Rusty had gone on the other side of the door. I said, you're not leaving. You'll have to run me over. And he responded, okay, good. And then the officer's report was after Rusty was on the other side of the door and had already begun to get in his car. He threatened to run me over and told me it would be my fault if he did it because I would have made him do it.
Okay, so when it comes to filling out an affidavit for the court, when you are asking for a protective order, you include the part where he says, according to your testimony, that he said he wouldn't hesitate to run you over, but you don't include the part that you told Officer Ledecky where you told him, I said to Mr. Whittaker, you'll have to run me over. You didn't include that in your protective order affidavit, did you?
I did not include that in my protective order affidavit.
All right. You understand that giving an affidavit is a statement under oath, do you not?
Yes,
Same oath you took today to tell the truth, the whole truth, and nothing but the truth, correct?
correct.
Okay. You didn't tell the whole truth then. If you're saying both of these statements are true, you didn't tell the whole truth to the court in your protective order affidavit, did you?
I would not agree with that.
Well, you certainly left out the part where you say to Mr. Whittaker, you're not leaving. You'll have to run me over or run over me. You left that out, right?
I'm sure there are many other things that I left out that happened that day that I didn't feel were a relative part of the narrative. I
It
mean,
would have been the whole truth to disclose to the court in your protective order affidavit that you're the one that said to Mr. Whittaker, you're not leaving, you'll have to run over me. That would have been the whole truth, right?
it doesn't change anything as far as the violence that occurred in that situation.
It twists the meaning completely around the opposite way. Wouldn't you agree?
No,
All right, I'm going to show you now what's been previously marked as Respondents Exhibit 44. You ever seen this document before?
I don't know if I have.
Okay. Show you down below. It recites that it's an affidavit for warrant of arrest and detention. And this same Officer Ledecky makes a sworn statement. You see that?
Yes,
Okay. Your Honor, I offer Respondents 44.
Same objection as to hearsay. It's a sworn statement of an officer for the truth of the matter asserted.
And public records exception, Your Honor.
Doesn't,
Well,
sorry.
I don't think this, I'm gonna have to sustain it, because I think that there's hearsay within hearsay here. But as to the exhibit, it's not coming in.
Well,
It's
if I might,
interesting because she has some statements in here that, you might can ask her about.
that's what I'd like to do, Your Honor.
Mm-hmm.
So, Ms. Whittaker,
yes, sir.
do you recall I took your deposition? Here
Judge, I would
just-
ask that the screen be, if it's not being admitted into evidence, then he can ask the questions from it without, I mean, I think there's a proper way to do it, and I don't think just leaving it up there is the proper way.
There you go.
Thank you.
Ms. Whittaker, I asked you, I took your deposition on November 24. Do you recall? A little over a week
recall.
ago.
Yes,
And in your deposition, I asked you specifically, we were having a discussion about what you consider violence. Do you recall that?
I don't know if I recall that specific discussion, but
And I specifically asked you whether or not you ever placed your hands on Mr. Whittaker in any kind of violent way. Do you recall that?
yes,
And you denied it several times. Do you recall that?
yes.
Okay. Did you or did you not tell Officer Ledecky that you pushed Mr. Whittaker at the outset of the altercation?
I don't recall what I told Officer Ludecky, but I stand by my statement that I've never put my hands on Rusty in anger or in violence.
Okay. If it says in Officer Ledecky's affidavit twice that you pushed him, meaning Mr. Whittaker, are you saying Officer Ledecky has it wrong?
I am saying that you're not reading the entire statement that Officer Ludecky put, and that it says not to hurt him, but to keep him from leaving, or something to that effect.
So on the 2019 incident, it's true, is it not, that you wanted him to help with the children, specifically Weston. He headed for the door. He was leaving, right?
Yes,
You didn't want him to leave, right?
Correct.
You didn't let him walk out the door, did you?
No.
At first, he didn't make it to the doorway. He only made it to the garage, and he got behind the garage door and sought to hold it shut because he didn't want any dealings with you. Correct?
I don't recall.
Well, you
I
said all
don't, I can't say that that's why he did what he was doing. I don't know what was going through his head.
there was a piece of this altercation where he's in the garage holding the door shut, and you're on the other side trying to pry it open. Agreed?
I don't recall.
Well, you didn't say that in your deposition?
I don't know if I was on the other side trying to pry it open. It was a very fast sequence of events. What I know is that Rusty tried to slam my leg in the door, and then he was leaving, and I felt it was a cowardly move for him to walk out of the house, not having even the slightest bit of a conversation about what was happening, that he left me when he told me he was going to take our son out of the house, and did the exact opposite, and then just up and left the house. I was absolutely upset about that. And then things escalated very quickly, which is when, after he left, I called the police because I was startled by what had just happened.
The whole time he's trying to leave and you're trying to prevent him from leaving, right?
He's not just trying to leave, he is just flat out ignoring a glaring problem and avoiding he's abandoning his family. He's not leaving. He's not leaving an escalated situation. He is abandoning his family because he doesn't want to deal.
But whatever your thought process is about his reasons, the bottom line is he wanted to go, right?
Yes.
Okay. And it's clear now from your testimony, you absolutely didn't want him to go and you were incensed by it, right?
Yes.
Okay. So the bottom line is he's trying to go. You're trying to hold him there somehow, some way. And he leaves anyway, right? At that
Yes.
point, nobody's harmed. Nobody's been injured, right? At that point?
No real injuries, just fear.
Okay. So you take it upon yourself to call the police without having been injured whatsoever when your husband's trying to leave and you're trying to restrain him. And you're upset that he left. Those are the facts as of the moment you called the police, correct?
No.
What did I say that was wrong?
I said that I was scared and didn't want him to return to the house, and I didn't know what to do, and that's why I called the police.
Isn't it true that you had threatened to take the children to San Antonio and Mr. Whittaker threatened to call the police if you took the children to San Antonio, and that's when you picked up the phone and called the police?
I can't speak to the sequence of events. I don't think that's how it happened, but I can't recall.
So really, there's this 2019 event, and that's the only time. Well, by the way, were there any injuries from the 2019 incident?
No.
No photos, no
Injuries.
no injuries. And Mr. Whittaker was arrested anyway, correct?
Yes.
Okay. So your counsel said at the outset of this case that there's a history and pattern of family violence. What is it?
I'm sorry, I don't understand the question.
What is the history or the pattern of family violence?
I think we've been talking about it.
Have we? Because it
Yes.
seems to me that in every event that you've recited, you've talked about not being injured, right?
Just because there's no injuries doesn't mean that it wasn't violent.
Well, so what we're really dealing with at bottom is argument and disagreement and leaving when somebody doesn't want the other party to leave, but no injuries. Where's the violence?
I believe that all of the things that I have stated happened were violent.
You also testified a little while ago about deception. Maybe you didn't use that word, but do you recall talking about Mr. Whittaker going to North Carolina and you not knowing anything about it, and you sort of testified about why you thought that was dishonest? Do you recall that?
I recall talking earlier about his trip to Tennessee. Yes.
Right. You guys had been separated for more than 6 months at that moment, right?
Yes.
Okay. I'm sure there's lots of things you didn't share with Mr. Whittaker about your comings and goings 6 months after separation. Would I be right about that?
Yes.
Okay. So there's not any necessary reason he would have shared with you where he was going, right?
Well, he did. He shared with me that he was going to attend Tebow Revival Conference.
Right. But if he was going other places, he wouldn't have any need to tell you that, would he?
I suppose not.
Right. Same as you wouldn't have the need to tell him all the places that you go on a daily basis. You're separated at this point. You're living separate lives, and you don't share absolutely every bit of information. Agreed?
Agreed.
So something else I covered in your deposition, I just want to hit it briefly, because you said you didn't have any idea why Mr. Whittaker, the whole incident about the camera and the window. Do you recall me asking in your deposition that you and he both had a mistrust for one another as it related to what we might call self-pleasuring or self-stimulation? You had an issue where you both didn't like each other doing that, right?
No, that was not. No, I wouldn't say that that was anything that was well talked about or discussed other than the incident in the therapy session.
But in your testimony, in your deposition, you said it the other way around. You said that was an ongoing issue between the two of you, right?
I said that we didn't have sex.
All right, I'll come back to that because I want to tee that up for later and not break my stride now. All right. Let's go over some property issues and then we'll get back to your children real quick. I want to ask you about your updated spreadsheet, your proposal to the court. So this is what's already been admitted in evidence as Petitioner's Exhibit 77. Do you recall, ma'am?
Yes.
Okay. The first thing that I want to ask you about is this LPL IRA. This is Mr. Whittaker's, what he started as a 401k from before marriage. Would you agree with that?
Yes.
And he had more than $300,000 in this account before marriage. Would you agree with that?
I don't know that for sure, but if there's documentation to support that, I would trust it.
Okay. If Mr. Whittaker can demonstrate that, and by the way, this account balance you've got as of the end of March 2024. That's nothing recent. Would you agree with that?
Correct.
So if Mr. Whittaker can demonstrate what ought to be his separate property out of that account, he should be awarded that. Would you agree?
I don't know that you should.
Why is that?
Well, I think there's a lot of factors that are gonna play into the separation of assets, so this could be maybe so, maybe not. I don't know.
Okay, do you think that there's any basis for a court of law to deprive Mr. Whittaker of his separate property?
Judge, I'm going to object. That calls for a legal conclusion that she's not in any
That's fine.
position
I'll ask
to.
another question, Your Honor. And this LPL Roth, you see that where I'm pointing, ma'am?
Yes,
100% of that was contributed by Mr. Whittaker before marriage and not touched since. Did you know that?
I don't know that.
If those turn out to be the facts, then that would be Mr. Whittaker's separate property. Would you agree?
Again, it's gonna depend on many things, but potentially, yes.
And I heard from your legal counsel questions that had to do with 52, this Victory Funds Roth, and it doesn't have much in it, but as I recall your testimony, you said that 100% of what's in that was contributed before marriage and you never touched it since, right?
I don't know that this is accurate. I don't know what this Victory Funds Roth for $5. I mean, I don't recall seeing an account
Well,
of that
maybe it was
value.
my
I feel
fault.
like,
Maybe it was my fault. Was it this other one that's 28,000 that you said that about?
this one is mine here.
Yes, ma'am. This is your spreadsheet, so I'm just asking you about these figures.
Okay,
Mr. Kazin, is there any way you can make it a little bit bigger, please?
I'll do that. It's going to cut something off, but sure.
Oh, okay.
So, ma'am, I'm asking you about these funds. Which one was it that you said was fully contributed before marriage and never touched since?
I believe my Victory Funds, that one at line 45, I believe is mine.
Okay, so this $28,000 item. And by that logic, if the same is true for Mr. Whittaker's Roth IRA for 18,000, then that should be awarded to him, right?
Perhaps in a normal such situation, yes.
Okay. Now, I want to ask you real quickly about line 43. And this is your retirement. You see that there, ma'am?
Yes,
And you heard me say in our opening statement that we agreed with your tracing and that the sum above $640,000 is your separate property. Did you hear me say that?
I believe so.
Now, here's something I don't understand. Perhaps you can explain it. You've got out of, and these are the goodness gracious. The funds held in trust are here. And out of those funds held in trust, you want Mr. Whittaker to be awarded $100,000, but for that to be a prepayment of child support. Do I understand your spreadsheet correctly, ma'am?
I believe so, yes.
Okay. What's his child support monthly obligation supposed to be?
I don't know. That's why we're here.
Well, I mean, what is your proposal about how much that gets worked off every month?
Well, the way that we came to that number was factoring in I think the $2,700 a month figure that is I guess the court-ordered child support amount for 3 children, factoring in 15 years until my last child emancipates, and that's a little less than a third of that, which would help me survive for the next 5-ish years, only based on the court-ordered maximum, which is woefully insubstantial to the expenses that I actually have for the children. But that's where we came up with that number. We figured if I can survive for 5 years, then I have some time to settle the situation, to get my life on track with my 3 children and plan for the future.
You understand that the court has to take current circumstances into account when determining what appropriate child support is, right?
Yes,
Is Mr. Whittaker earning any money at the moment?
Mr. Whittaker has an estate at the moment. He's not earning any money per se, but he has an asset. He has resources to support his children.
Well, on what basis is there to determine that the full guideline amount of $2,760 ought to be the appropriate amount?
Because Mr. Whittaker is unable to care for his children in any meaningful way while he is incarcerated.
He's also unable to earn money. Would you agree with that?
He has an estate. Yes, I agree. I actually don't agree that he's not able to earn money, because even you said it earlier that he invests money. And so he absolutely has a way to earn money.
Okay.
And I'm sure he'll figure it out.
And if he's awarded a decent amount of the estate that he has to divide with you, and he's awarded his separate property, then he can invest that and pay his child support monthly. Shouldn't he be allowed to do that?
No,
And why is that?
because he's untrustworthy.
Untrustworthy with money, really?
Yes.
Well, I see you've got all these complaints here about things that are connected to his current circumstance, but apart from these, in what way has he been untrustworthy with money?
Rusty is a financial planner, and he managed our finances during our marriage. And well, for one, the fact that the separate property claims have not emerged for the home until the very end here is part of it. For two, he rolled over one of my assets that I had prior to marriage that would have been separate property into an asset that is community property to complicate the ability to untangle what's separate property and what's not.
Well, wait a minute. Let me stop you there. You've done a tracing to figure out that what's separate versus community, correct?
Correct, which cost me dearly in attorney fees to do so.
So you're saying that he did that on purpose years ago in anticipation of a divorce?
Yes,
When was that, ma'am?
I don't recall exactly when we rolled it over. I think it was 2019 or 2020. Maybe it was before. I don't recall. I can't answer that question.
Okay. Well, let me ask you about a few of these items here. I want to try to confine our discussion for a moment to this area right here. Do you see the box that I've just drawn?
Yes.
Okay. I'm going to take this down for a second and show you a different document. I'll show you. So until this morning, this is what I thought your property division was, your requested property division. I want to show you right here. So you had the estate at 2.2 yesterday or sometime before today. And you were to receive 1.5 and Mr. Whittaker was to receive 6.6, $662,000. You would have been fine under this scenario getting $1.5 million, agreed?
This spreadsheet has been manipulated and changed so many times and not by me. What I want is to be able to care for my children. That's what I care about. I care about being able to care for my children. So I don't know I don't know if this includes what's not been paid out on the business. I really can't speak to these numbers at the moment because I don't know what's included.
This was your proposal, was it not? On the date that we had to get these into the court as pretrial proposed disposition of issues?
And Judge, to clarify, like Mr. Kazin did previously, this did not include the future payments that were remaining on the business, which is why the spreadsheet is different. And so that is absolutely, it is missing 990,000 or 909 or whatever it is now because of the update that Mr. Kazin had this weekend.
Thank you.
So back to your other. All right, so this is your new proposed property division. And you're proposing that Mr. Whittaker gets $894,000. But out of that, you're also suggesting that includes these attorney's fees for $23,000 and change. That money doesn't now exist in the community estate. Would you agree?
That's already been spent. Yeah, I've already paid that. I don't know how we're gonna document attorney fees on this. I don't know how we're gonna, I'm not an accountant. Spreadsheets make my head spin, so I don't know.
Okay, my only question is that money's not there anymore, right?
I have paid that bill to Coldwell Bose, but I don't know if it's being tracked in these numbers.
Okay, so out of $894,000, the way it gets built up, according to this spreadsheet, is that $23,000, and then this $816 that was spent at T-Mobile. That's money that's no longer in the estate. Would you agree?
Yes.
And then all of these numbers here that are no longer in the estate, they are for Pokemon cards, and Criminal Defense Counsel. All of these funds are not really in the estate any longer in this $894,000. Would you agree with that?
I don't know. I don't know.
Well, it's not somewhere where you can go get it, right? That money is gone.
Again, it was distributed from the funds being held in the trust accounts, and I don't know if we are factoring these numbers based on the total amount that was deposited into the trust accounts when we sold the house, when we sold the business, or what we expect to receive in total from the business. I don't know if we're working from those whole numbers that were at the beginning, or if we're working from the deductions. I don't know that.
Do you know whether or not these sums here where my hand is running across, these don't exist anymore. They're not in the community estate, right? They're spent sums, are they not?
They have been paid out of the trust accounts, yes.
Okay. So in reality, and he's not getting this $100,000 that's in this column either, because that's going to child support. So in reality, all you're really proposing that Mr. Whittaker gets is these future payments from the sale of the business that he built, and then a portion of his LPL Roth. You're not even suggesting he gets all of his LPL Roth. You not only don't give any credit for separate property here, but you want $330,000 in your column out of that money. Do I understand correctly?
I actually think that was a mistake. I don't think that I'm trying to take his 401k. Or at least not what was separate property. I don't know, Michelle, this doesn't seem right to me, but.
Okay, so you're not
But again,
asking.
how we have shifted numbers on the spreadsheet, I'm not sure. If this was intentional, I don't think it was, but I don't know, but regardless.
All right, and I appreciate that, but just the way it recites here, he's getting in actual dollars, really, the big chunks are this $141,000, some of these smaller accounts here, not really this 100 because it's going to the OAG, and some future payments, and the rest is no longer in the estate.
Well, I don't really like how, I don't like saying that 100,000 is not what he's getting, because what I'm getting, I'm spending most of my income on the children as well. So, I mean, he's absolutely getting that money, but he has 3 children and he has an obligation to care for them. So I you know, same as I do. So I don't think that's a fair, pulling out of his portion of the assets, or the way that you worded that. I don't agree with it.
Meanwhile, you're suggesting to the court you get $2.1 million. That's your proposal.
Most of that is in illiquid assets. That does not include tax payments that will need to be made, and that does not include attorney fees that have been incurred and not paid to date. So it's you know, if I receive, you know, we have to pay capital gains on the business. If I receive a bigger distribution of the business, then I'm going to have to pay a bigger portion of the taxes for that. And also, I am thinking what is needed moving forward, and me as a single mother of 3 young children by myself, trying to make up for the absence of their father and incurring significantly more expenses to care for my children. I definitely need a greater distribution of our estate. And, you know, I don't know how expensive it is to pay your bills in jail, but I don't think that Mr. Whittaker has a lot of expenses at the moment.
How did you come up with the amount that Mr. Whittaker owes in child support, full maximum guidelines? How
Judge
did you-
asked and answered.
Well,
Overruled, you can answer.
I believe that we factored that number based on, I think after doing the math, if he were to pay me the $2,750 or whatever it is per month until my last child emancipates, it would be between $350,000 and $400,000. And so I was asking to shelter $100,000 of that to be prepaid in child support, taking into account that Mr. Whittaker is unemployed and will likely be unemployed for the remainder of our children's time under my roof. And considering that we have a sizable estate today that we can pull from to take care of our children. And I feel that he is absolutely responsible for that, whether or not he has an income, because we are in the position that we're in solely because of his actions.
Well, okay, ma'am, but I asked you about the calculations and I'm showing you on the screen Respondents Exhibit 30, which I'm offering at this time, and I'll suggest to you they're your answers to interrogatories. So I offer R30.
I don't have any objections.
R30 is admitted.
So ma'am, you were asked interrogatory number 12 to state the calculations you used to determine the amount. You didn't provide any, you provided an answer similar to what you just gave us, but the numbers themselves we didn't get until today. Would you agree with that?
I don't know when you got the numbers.
Well, you didn't give them in your answers to interrogatories. Do you agree with that?
Yes.
Now, your testimony today before the court is that Mr. Whittaker has been abusive all throughout your relationship with him. Is that generally correct, ma'am?
Yes.
If one were listening to you today, it would sound like there were never any good times. But that's not the case, is it?
No.
I'm showing you R35. You've seen this document before?
Yes.
This is a sequential compilation of all the messages that you and Mr. Whittaker sent to each other throughout your relationship. Would you agree?
This is a compilation of the happy moments, correct?
Offer R35.
Judge, I just need a date on this document because I don't think it's dated when it was sent to my client.
This was actually a book.
This is a book that Mr. Whittaker gave to you, correct?
Yes.
Okay, offer R35.
Judge, the same objection. I don't know the date that this book was given, and I think the date's relevant.
Do we know a date? Is it possible to ask her to
Sure,
clarify
I can
the
ask
date?
her. I can ask her, Your Honor. I don't know that it's required as part of the foundation, but I'll ask her. Ms. Whittaker, when did you receive this book?
I received this book in December of 2022 after I found Rusty with a camera in my bedroom window.
Objection non-responsive to the camera part of it. I just asked.
Sustained, December 2022 is what I heard as the answer. So, Ms. Locke, are you okay with the exhibit now?
I am, Judge. Thank you.
What number is it, Mr. Kazin?
It's marked as
And you-
R35.
R35 is admitted. And I'm going to have to be honest with you. I don't think I've said this in 4 years of doing Zoom, but you're making me dizzy. Like you just keep moving the exhibit around and I'm trying to follow it, but it's actually causing me to have some like headache. So if you could not move it around quite as much, that would be helpful.
Okay.
All right. Thank you.
Ms. Whittaker, you see what I'm highlighting for you?
Sure do.
These are things you said to Mr. Whittaker?
These are, yes. I don't know when this letter was written, but this was very early on in the relationship.
And you and Mr. Whittaker would write each other these kinds of notes through most birthdays and Valentine's days?
We generally did nice things on birthdays and holidays, yes.
So contrary to what you started out saying earlier today, Mr. Whittaker was not abusive almost all the time. Would you agree with that?
In the beginning, it was wonderful. In the beginning, it was a fairy tale.
Okay, I'm going to scroll slowly so that I don't upset anybody, but this document apparently goes on for 73 pages and has one after another representation by the two of you of your love and affection for each other. And then when you start to have children, it incorporates them as well. You agree with all that?
Yes,
And it's not just Mr. Whittaker's direction to you. It's you're writing him these same kinds of things. You agree with that?
yes.
And it was this way all the way up until really with some ups and downs. It was that way through, say, November of 22. Would you agree with that?
No,
Well, there were times even since November of 22, after you separated, that you were engaged in all kinds of activities with each other. You don't agree?
we were engaged in activities together. Yes, we were married. We had children.
Right, but you spent a lot of time socializing with each other even without your children. Would you agree with that?
Yes,
So Mr. Whittaker was arrested in early June of 2023. Is that correct?
correct.
And in March of 2023, you and he were planning on going to a wedding together in Europe. Agreed?
We were discussing it. Yes,
In April of 2023, you showed up at his home in the middle of the night to knock on his door because you wanted to be the first to wake him up and say happy birthday. Agreed?
that's not how it happened. But yes, I did. I had made a video for him that was too large to send via text message, and it actually gave me a lot of joy to make the video for him. And I was excited to give it to him as a peace offering and an olive branch to set the tone for our co-parenting relationship moving forward.
And in May of 2023, you invited him to a Mother's Day brunch that he declined. Is that correct?
I don't recall.
In May of 2023, you have a mutual friend named Ryan whose son was giving a presentation. Do you recall that?
Yes,
And you texted Mr. Whittaker about saving a seat for him. Is that correct?
I don't recall, but I wouldn't deny it.
So basically, your entire relationship with Mr. Whittaker, even though you had your ups and downs, wasn't abusive at all. But you're calling it now abusive because of his current circumstance. That's all correct, isn't it?
No,
Well, have you explained everything that you think Mr. Whittaker was abusive about to this court already, or is there more that we're missing?
I have not. A lot of the abuse was non-physical abuse. There was a lot of emotional abuse. There was gaslighting. There was the silent treatment, stonewalling,
It's
verbal. There was a
it's-
lot of verbal and non-physical abuse in the relationship that we have not discussed in great detail, and I don't know that it really makes a difference in the situation moving forward as far as the kids are concerned and the situation that we're in. So I was advised not to put that in a protective order simply because for a protective order, they wanted the violent incidents. So that's what I focused on in my protective order, which is what we reviewed today.
you went with the best of the best for your declaration for your protective order, didn't you?
I'm
I
gonna object
actually-
I'm gonna object as a mischaracterization of her testimony.
Stained, rephrase your question.
Sure. When you put together a declaration supporting your request for a protective order, you put together the best examples that you had of family violence. Would you agree?
I put together the examples of physical violence.
And yet nobody was harmed in any of them. Agreed.
Correct.
Now, you make between $200,000 and $400,000 a year in your occupation, don't you?
Historically, no, historically, I have made, at the job that I'm in, anywhere from, I think, 170,000 to, my best year is 400,000.
Showing you now, respondents exhibit number 37. Do you recognize that as your 2019 W-2?
Yes,
And if we scroll and keep going, do you see the next page is your 2020 W-2?
yes,
And then if we keep going, it scrolls and shows your 2021 W-2.
yes,
And then we see your 2022 W-2.
yes.
Judge, the only concern I have is that I don't think he's redacted my client's personal information and we're sharing it on an open forum, so I'd ask to be pulled down.
I don't have any problem with that. I will redact them. I wish that I'd thought of that ahead of time, but I nonetheless and counsel, if you clarify, I can redact employer identification numbers and social security numbers. Is there anything else that you would like redacted?
No, I just need the identifying information redacted, please.
Okay, Your Honor, I'd like to offer the exhibit, even though I don't have a handy one that's redacted, but I promise to redact employer identification numbers and social security numbers.
What number is it?
It is respondents 37.
I mean, I can admit it with the fact that you're going to make those changes, but I still don't think it solves the problem that you can't show it to the witness right now because we're on Zoom.
I'll
we're on YouTube.
I'll just ask her about her memory of her top line numbers, Your Honor.
All right, you can go forward with that.
So Ms. Whittaker, in 2019, the top line income, gross income number that is reflected on your W-2 is $416,122.14. Do you agree or disagree?
That sounds right.
And then in 2020, your top line number of your W-2 is $185,428.18. Does that
I
sound
thought
about
I
right?
saw a number of 176,000, but sure, no, the gist is there.
Whether it's 176 or 185, it's in that range.
Yes,
And then in 2020, your W-2 reflects top line number of $254,682.11. You agree?
sounds approximate, yes.
And then in 2022, your top line number in your W-2 is $253,141.41.
Yes,
And then in 2023, it's back up again to $428,000 I'm sorry, let me restate that. $428,065.72. Does that sound accurate?
yes,
And so far this year, you've already made gross income of approximately $300,000. Agreed?
no,
If you average together just the 2019 through 2023 W-2s, top line numbers, you agree with me that it comes to just shy of $300,000.
that is what I have historically made in a commission-based role with a co-parent, yes.
No, I'm bouncing around and I apologize about that, but the children absolutely adore their father. Would you agree with that?
They like their father, yes.
You disagree when I use the word adore?
Sure, they adore their father.
As a matter of fact, in your deposition, you explained that making children like you is part of what Mr. Whittaker does that's abusive. Do you recall that?
I don't recall if I said exactly those words, but yes, abuse is manipulative and it's not all bad, as you have shown.
I believe you said his behavior is manipulative and it's abusive, and these predators of children make children love and adore them, and that's part of the abuse. Does that sound like what you said?
Sounds like something I would say, yes.
So all of those good time pictures that I showed the court of your family life and how much the children really enjoy their father, that's part of what you say is abuse. Is that correct?
Yes. I say it's a part of the abuse cycle. That part itself is not abusive, but it is part of the abuse cycle. And the fact that he made me a book right after I caught him in such a horrible act, the timing of it is also a part of the abuse cycle.
Ma'am, the pictures that I showed you of the family life indicate you really seem, compared to most people, you really had it all. You had a wonderful family life. You had trips and golfing outings and kids with full activities and full lives. You really did have it all at one point in time. Would you agree with that?
I think there were a lot of things that we were fighting for to save the marriage because there were a lot of things working in our favor.
Right. You're resentful because you no longer have everything that you used to have. Would you agree with that?
I would say that is only a small part of what's making me resentful, yes.
Showing you what's been marked respondents exhibit number 32. Do you recall this post, ma'am?
Yes,
You wrote it, did you not?
yes.
You meant it when you wrote it, didn't you?
This is actually, I have a lot to say about this, but I don't know how the court wants me to respond. This was, on the heels of the incident, I believe, of the arrest, and there was a rebound reconciliation, and it's again a part of what happens in abusive relationships, and I believe this to be an overcompensation of what had just happened and a desire to heal the marriage and a desire to give Rusty the praise and attention that he needs to prevent him from lashing out.
You wrote this. The overcompensation you're talking about is on your part, right?
Yes.
He didn't compose this at all, did he?
No.
And everything you said in it was true at the time. You believed it, didn't you?
Yes.
This guy is everything and more. A best friend, master castle builder, fishing partner, pumpkin carver, golf instructor, gingerbread house decorator, nap time snuggler, swim coach, heavy lifter, date night and vacation planner. And it goes on and on. Expert pancake maker, baseball coach, alien shooter, prayer leader, not afraid to get his hands dirty, tells us he loves us every day, 100 times a day. That's not a bad thing, is it?
Again, this is the image that we're crafting for the Facebook world.
Your Honor, I'm going to pass a witness and I'll reserve any additional questions for the witness in my case in chief.
I'm not for sure you can do that or not do that, but we'll see. I mean, if you want to call her later, maybe as rebuttal, I don't really know, but I don't think you can do it that way. She's been called as a witness, and now is your time to cross her. If you want to, I mean, I bet Miss Locke has some questions. She's not probably going to stop, and so you'll probably get a chance to cross some more. But I don't think you get to recall her in your case in chief. I just don't think that's how we want to do it. Plus, we're time limited, so I'm just being thoughtful about time. Miss Locke, any questions?
Just a few. Miss Whittaker, that R32 exhibit that you wanted to explain a little bit more about. What is it you want the court to know about that exhibit?
Which exhibit are you talking about?
That was that post, and that was when Desi was born. Is that right?
The one that we were just looking at?
Yes, ma'am.
Yes,
Okay, what year was that?
2019.
Okay. And what is it important for the court to know about that particular post that you didn't get an opportunity to explain with Mr. Kazin?
I feel, again, I have a lot more clarity now being out of an abusive relationship, not really realizing how I was being manipulated and, blame. I mean, you can see in the text messages, I don't know that we've shown them, but the text thread after his arrest, everything that happened, he's blaming me for everything that happened. He was the one that was abusive and violent, and then it's my fault. Everything is my fault. And when you're in that kind of a relationship and you're beat down and weakened, you start to believe that you're responsible, and you start to apologize for things you shouldn't apologize for, and you start to overcompensate because you're desperate for the good times. And there were good times that I believed were real at the time that I don't believe are real now. But at the time, I believed that they were real, and I believed that there was a lot worth fighting for in the relationship at that time. And Rusty, it seemed a theme that the blowouts would happen when he didn't feel he was getting enough attention or praise or validation in what he was doing. Then he felt justified in creating chaos. All of the events, the big horrible events that happened in our marriage were chaotic and devastating and lasted over a long span of time. And I believe that, this is what an abused woman does to
I'm
try
gonna
and
object to the
preserve.
narrative. I've lost track of the question, Your Honor.
I do think at this point it's a narrative.
I
So
don't disagree,
sustain.
Judge. Ms. Whittaker, let's talk about what has changed in your life and your knowledge of Mr. Whittaker since all of these love posts and Facebook posts and the book. I mean, what have you found out since?
I found out that he was arrested for raping, sodomizing, and
Objection.
hospitalizing a
Facts, not
child.
evidence. To the extent she has anything to say about it, it's hearsay, Your Honor.
And the arrest happened. The arrest is real. That's not
Ms.
hearsay.
Whittaker, stop, please.
Sorry.
I think that perhaps there was some non-responsiveness to the question. It went on a little bit, but I'm going to overrule the objection. I think that's the problem, Mr. Kazin, for you and your client ultimately, is it's a best interest of the child case. And the court has to allow evidence that allows me to make rulings about the best interest of the children. I've been consistent about this for 14, 15 years, and I haven't gotten reversed yet. I don't think the rules that you're talking about regarding criminal cases and what comes in and doesn't come in with regard to criminal guilt, I just don't think they're the same when what comes in with regard to best interest of children in a family law case. I have a much larger strike zone, and I've always tried cases that way. Now, to your point, we have to be more careful than how we just were, Ms. Locke. We still have to follow the rules of evidence, but we're not going to keep out the fact that Mr. Whittaker sits in jail on an arrest. That's sort of why we're here, I think. So I don't really think if that's what you appeal me on, Mr. Kaysen, and you ultimately win, then you're going to prevail. But it's not going to keep me from going forward and hearing evidence regarding best interest of the children, regarding the single most important fact in the case. We're just not going to do that. So your objection is overruled. But Ms. Locke, I need you and your client to proceed carefully. She needs to continue to answer the questions that you ask and not go off on her own tangents. Go
Judge,
ahead.
I'm actually going to pass the witness.
All right. Mr. Kazin, you have anything else?
I do, but I think given the constraints of where we are, I'm not going to ask any further questions at this time.
All right. Then we're going to be done for the day. The only thing I'm going to ask the two of you is who we have tomorrow. I know we have Mr. Whittaker. What else do we have to do?
I have Sonia Desai for sure to talk about the tracing. I think Mr. Kazin, while he has stipulated to our tracing, we have the issue with Mr. Whittaker's own personal tracing that Ms. Desai will deal with. So she'll be called limited for that purpose. Big focus tomorrow is going to be Mr. Whittaker.
What about you, Mr. Kaysen? Other than Mr. Whittaker, who other witnesses do you have?
I have 2 supervisors from supervised visits. I have a mutual friend of theirs who supervised the first 2 visits.
And we have an objection to him, Judge, just because he's not listed on request for disclosures from them, but I guess we can deal with that tomorrow.
We've supplemented that, but
We can talk about it tomorrow, but they're short. Those can't be very long.
they're all
not.
short. There's the best man from his wedding who's in Las Vegas, but he's known him since they grew up together as childhood friends, and he's known him ever since.
Okay.
There's
Okay, but you're going to have all these people ready to go. To the extent
Yeah.
you're going to have a fact witness ready, they're going to be sitting in the hole ready to go when it's their time to call.
I'm going to aim for that as much as humanly possible, Your Honor.
And then you're going to have Ms. Desai first thing, Ms. Locke. Is that your plan?
I missed
Or are
that
you
question.
you're going to go with Mr. Whittaker first? Are you going to go with Mr. Whittaker first or Ms. Desai first?
Mr. Whittaker, because Ms. Desai is only available tomorrow between 12 to 1, 2 to 3, and 4 to 5.
Okay. Well, then I
We
will
can't
see
go
everybody.
4 to 5. Right.
Right. Well, I'll see everybody at 9 a.m.
And Your
And-
Honor, she can use her time to the extent she's got it, however she wishes. But I want to be, given how constrained we really, really are, I insist on getting equal time, and I don't, we've stipulated to her report. And
He's
their-
got about an hour left and the rest of the time's you. So I think that's where you are. Maybe an hour and 15 minutes, but I'm not too worried about time. I mean, if y'all make me stay late tomorrow, I'll stay late tomorrow. You'll upset your colleague, Miss Weinman, who won't get her hearing, but that's fine with me. You'll take it up with Miss Weinman. But I can go late tomorrow, and I'll just blame that on blame it on y'all for Miss Weinman's sake. So
You can blame it on me,
she's-
Judge. That's all right.
all right. But I'll go till 5 tomorrow. If he can stay till 6, I can stay till 5. I'd like us to be thoughtful about time, and I'd like us to try to finish tomorrow. But I'm not going to keep you from putting on your client to adequate amount of time, Mr. Kaysen. Now, some of these other witnesses that are character witnesses, call them quickly. They're not going to take very long. All right. See y'all tomorrow, 9
Thank you,
a.m.,
Judge.
10 a.m. Eastern.